Motion approved. Let's have order in the court, please. All rise.
You may be seated, thank you. The residual hearsay exception to hearsay is to be used very rarely and only in exceptional circumstances, and only when there exist certain exceptional guarantees of trustworthiness and high degrees of probativeness and necessity. And that is a quote from Miller v. State 303, Georgia 1, a 2018 case. With regard to trustworthiness, the focus is on the trustworthiness of the declarant's statement. So in this case, it would be the trustworthiness of anitra-gunn statement, not of the witness before me. And the trustworthiness is at the time the statement was made, not the trustworthiness today. Taking into consideration the nature of the relationship between the declarant, in this case Ms. Gunn, and the witness. In Miller, the witness's testimony was allowed because the witness had known the declarant for 3 decades, had maintained a close personal relationship during that time, and that when the declarant made the statement declaring the defendant to be her attacker, the declarant had a busted lip, a missing tooth, and broken eyeglasses. Here, the state proffered no evidence about the circumstances surrounding any statements made by anitra-gunn. The proffered witnesses only knew anitra-gunn for a few years or less. The state has not met its burden to show exceptional guarantees of trustworthiness. With regard to probativeness, the statements must be highly probative of motive for the crimes at bar. It should be more probative of the relationship troubles between the defendant and the victim than any other evidence. While the state argued that it has no other evidence of anitra-gunn's oral statements to these witnesses, that is not the proper standard. The state admitted that it has other evidence of the relationship trouble between anitra-gunn and DeMarcus Little, including Mr. Little's statements and text messages showing his version of those events. The court orders that the testimony from the proffered witnesses about statements made to them by anitra-gunn are inadmissible. This ruling does not preclude these witnesses from testifying regarding matters that they personally observed and witnessed. Moving to the issue of whether or not Miss Gunn's father and brother can remain in the courtroom, I've looked at OCGA 17-17-9. This is exclusion of testifying victim from criminal proceedings and has to do with victims' rights. There's also a case, Thompson v. State, it's a Supreme Court of Georgia case that was decided on June 1st of 2020. Both of these cases seem to indicate to me that family members of the victim would be allowed to remain in the courtroom. If there's a motion to exclude a victim or family members from the courtroom for any reason other than misconduct, then there needs to be a showing that the victim or family member is a material and necessary witness in the trial, and that the court finds there is a substantial probability that such person's presence would impair the conduct of a fair trial. And so I will ask you, Ms. Baskins, to proffer into evidence what the testimony of the dad and the brother will be, so that I can make a determination whether or not I find them to be a material and necessary witness in the hearing.
Thank you, Your Honor. Christopher Gellman.
No, we'll withdraw any objection to the father and the brother remaining in the courtroom.
Okay, they shall remain in the courtroom. All right. Is there anything else the court needs to take up before we get our jury in here? Anything from the state?
Your Honor, we could have just a very brief moment to make sure that the opening accurately reflects the court's ruling.
Okay, that's fair enough.
Thank you, Your Honor.
All right, is the state ready?
Yes, Your Honor.
Mr. Davis, is the defense ready?
Yes, Your Honor.
Okay, all right, bring in the jury. Y'all can take your seats, thank you. Good morning, ladies and gentlemen. I hope y'all got some rest after the long day that we had yesterday. I know I did. The court apologizes for making you wait this morning. You're going to see throughout the course of this trial, there'll be many times when you're sitting back there waiting because we have to take up some issues that cannot be taken up in front of you. That's normal, and remember I told you yesterday that we appreciate your patience and you need a lot of it when you're sitting on a jury, okay? But we're ready to proceed this morning. The first thing I need to do is administer yet another oath. So now that you're nice and comfy and seated, if you'll stand and raise your right hand. You shall well and truly try the issue formed upon this bill of indictment between the state of Georgia and DeMarcus Little, who was charged with, I read you the indictment yesterday, there's a malice murder, a felony murder, and an aggravated assault. And a true verdict give according to the evidence, so help you God. All right, you can be seated. All right, the rule of sequestration has been invoked, so all witnesses should remain outside of the courtroom except when you're personally called to testify. There is an exception for Agent Nunez with the GPI and with Ms. Gunn's father and brother. They can remain in the courtroom even though they're expected to testify. Additionally, all witnesses should not discuss the case with the other witnesses or parties until the evidence is concluded or you have been excused from further appearance. All right. I've asked the bailiff to provide you with some pencils and notepads for your use during the trial. You may take notes, but you are not required to do so. If you decide to take notes, please remember that note-taking should not divert you from paying full attention to the evidence and evaluating witness credibility. Your observations of the witness during their testimony can be vital to your determination of the believability of their testimony. The notes that you take are for your use only and are not to be shared with anyone until you begin deliberation with your fellow jurors. During deliberation, you should rely on your own recollection of the proceedings, but you may consult the notes of other jurors if you wish. Do not be influenced by the notes of other jurors unless their notes help you in determining your own independent recollection. Notes are not entitled to any greater weight than the recollection or impression of each juror as to what the evidence may have been. After the trial is over, the notes will be collected and destroyed. The law requires that you decide this case solely upon evidence presented in this courtroom. This means that during the trial, you must not conduct any independent research about this case, the matters in the case, or any individuals involved in the case. In other words, you should not consult dictionaries or reference materials, search the internet, websites, or blogs, or use any other electronic tools to obtain information about this case or to help you decide the case. Please do not try to find out information from any source outside the confines of this courtroom, to include media of any sort or online research. The bailiffs have been instructed to collect your cell phones and tablets or laptop computers during the proceedings. You can use those in your vehicle or on your brakes, okay? But you certainly cannot use those to look at the internet or social media or anything like that, and you should not bring them into the courtroom, okay? Until you retire to deliberate, you may not discuss this case with anyone, even your fellow jurors. After you retire to deliberate, you may begin discussing the case with your fellow jurors, but you cannot discuss the case with anyone else until you have returned a verdict and the case is at an end. I will tell you specifically when you're allowed to discuss it with other people, but it will be after this trial is completely over, okay? I hope that for all of you, this case is interesting and noteworthy. I know that many of you use tools of technology in your daily life, but you're not allowed to do so in connection with your service as a juror. You also must not talk to anyone about this case or use these electronic tools to communicate with anyone about this case. This includes your family and friends. You may not communicate with anyone about the case or your jury service via the internet, text messaging, email, Twitter, Facebook, Instagram, Snapchat, YouTube. It goes on and on. Internet, chat rooms, y'all get the idea. And I will remind you of that several times, because it seems that no matter how many times folks are reminded, there are folks who violate that rule. So that is a very, very important rule. I cannot stress strongly enough that communication via electronic devices is prohibited. Okay, so that is an order. You may sit in any of the seats in the jury box during the trial. During the voir dire process, we ask that you sit in specific seats for identification purposes. However, there's no need to do so during the trial itself. If you need anything while in the jury room, you may knock at the door to notify the bailiff that you wish to communicate with the court. I would then give you instructions on how this should be done depending on the stage of the trial and the nature of your request. I frequently have jurors ask me if they can bring water or soda or something like that in the courtroom. I will allow you to bring a bottle of water with you. When you're in the jury deliberation room, I hope you saw that I provided you some snacks, and there's some sodas in there, but leave all of that in the jury room. And in the afternoon, I will bring in a coffee station for those of you who enjoy coffee. I know some folks have to have their afternoon coffee to stay awake, and we certainly want you to stay awake, okay? So we'll try our best to take good care of you. I believe it might be helpful if I give you some preliminary instructions concerning criminal law and trial procedure that will apply in this criminal case. A crime is a violation of a statute of this state in which there shall be a union or joint operation of act and intention. That is, a crime is committed when a person violates a statute of the state by acting as prohibited, while at the same time he has a criminal intention and no other defense excuses the conduct. A person will not be presumed to act with criminal intention. However, the jury may find such intention upon consideration of the words, conduct, demeanor, motive, and all other circumstances connected with the act for which the accused is prosecuted. The state cannot bring a person accused of a felony to trial unless the grand jury has first indicted that person. Grand jurors do not try criminal cases. They ordinarily only hear from the witnesses for the state. When a criminal case is tried, the defendant has pled not guilty to the indictment. This plea of not guilty denies every essential allegation of the indictment and forms the issue or question that you, as a trial jury, will decide. The indictment and the plea of not guilty to it are not evidence, and you should not consider them as evidence. Every person is presumed innocent until proved guilty. No person shall be convicted of a crime unless each element of the crime is proved beyond a reasonable doubt. The state has the burden to prove every essential element of each crime charged beyond a reasonable doubt. In this state, a defendant on trial may or may not testify as he chooses. If he does testify, you would judge his credibility by the same test applied to any other witness. If the defendant does not testify, which is his absolute constitutional right, you shall not draw any inference of guilt from this decision, and his election not to testify may not in any way affect your verdict. Moreover, the defendant has no duty to call any witnesses or present any evidence during a trial. If he calls no witnesses or presents no evidence, you may not derive any inference of guilt from such failure to produce evidence. In such case, you decide guilt on whether the state's evidence proves the defendant guilty beyond a reasonable doubt. Under our system, I have the duty as the trial judge to decide the law that applies to a case and to instruct you on it. You have the duty as the jury to decide the facts in a case from the evidence and reasonable inferences arising from the evidence. In reaching your verdict, you also have the duty to apply the law that I will give you to those facts. You decide the facts from the evidence. The evidence has two parts: testimony of witnesses and exhibits. A witness means anyone who testifies in person from this witness stand. The exhibits are those documents, objects, photos, etc., that the court admits into evidence. You will have most of the exhibits with you in the jury room while you deliberate. However, there may be some exhibits that cannot be sent to the jury room, so it will be important that you pay close attention to all of the exhibits admitted during the trial. I caution you that what the lawyers say during a trial is not evidence. Also, anything that I might do or say is not evidence. I have no leanings at all in these cases. My only interest is to have the cases tried fairly and according to the law and the constitutions of this state and the United States. You are the exclusive judges of the witness's credibility. That is, you decide the truthfulness and reasonableness of their testimony. You may believe or disbelieve all or any part of the testimony of any witness. You have the duty to decide what testimony is worthy of belief and what testimony is not worthy of belief. You should lay aside any preconceived notions and not decide a witness's credibility until the witness has testified. Rules of law govern what the court admits into evidence. If an attorney objects to the admission of evidence, then I must rule on the objection and decide whether you can consider such evidence. You should understand that there are two ways that I can respond to an objection. If I say sustained, then that means that I granted the objection and you should not consider the objected to evidence. If I say overruled, then that means I did not grant the objection and you may consider the objected to evidence. It'll be clear to you whether or not you can consider the evidence, okay? Because if it's ruled out, then the person won't continue to testify regarding it, okay? But if you have any concerns, if you're confused about that, you let us know, okay? You should not infer or assume anything from either the lawyer's objections or the court's rulings. During this trial, the court will have to consider some procedures outside of your presence. That's what happened this morning. When that occurs, I shall excuse you to the jury room for a time. During these periods, the court will do its best to handle the matter as promptly as the law permits. On the other hand, I will appreciate your patience when these occur. As I told you yesterday, the utmost importance is that there is a fair trial. If it means that it takes longer and that we have to wait longer, that's what we will do, okay? So I want to make sure that y'all understand that I need your patience this week. The procedure in a criminal trial is generally as follows. First, the attorneys for both sides may make an opening statement to you. This opening statement is not evidence itself. Remember that what the lawyers say is not evidence. However, it is a preview or an outline of what they expect the evidence to show. Following the opening statements, the state has the opportunity to present evidence to support the charges against the defendant, and the defendant has the opportunity, if he so elects, to present evidence in his defense. This part of a trial is called each party's case in chief. In the state's case in chief, the state calls its witnesses and introduces any exhibits. When these witnesses testify, they may be cross-examined by the defendant. When the state has presented all its evidence, the state will rest its case. Then, if the defendant elects to present any evidence, the defendant may call his witnesses and introduce his exhibits. Of course, when these witnesses testify, they may be cross-examined by the state. However, remember, the defendant has no duty to testify or to present any evidence whatsoever. After the presentation of the evidence, the attorneys may make a closing argument to you. At this time, the attorneys will try to persuade you to decide the case in their favor. Following the closing arguments, I will charge or instruct you more specifically on the law that directly applies to this case. Then you will retire to the jury room to deliberate and reach your verdict. This is not an exhaustive description of the procedure in a criminal trial, but hopefully it will give you a quick overview that will help you to understand the trial as it proceeds. It is your duty to follow any instructions that the court may give you during a case. Please remember to listen carefully to all the evidence. Do not jump to conclusions before the parties present all the evidence. Also, please remember that during a trial, it would be improper for you to discuss the case with anyone or to allow anyone to discuss the case with you or in your presence or within your hearing. This applies even to discussions among you. Under this rule, you should not engage in even social greetings or small talk with anyone involved with this case. I have had situations where the juror saw a party or attorney in a parking lot during a break or some sort and were offended that the attorney or party did not speak to the juror. Please understand that these attorneys and parties should not speak with you as the trial progresses and will likely avoid speaking with you to ensure that there is no appearance of impropriety. So please do not take offense to their failure to speak with you as we go forward with trial this week. This procedure will protect you not only from wrongdoing, but from the appearance of wrongdoing. And these restrictions also apply to the friends and family members of interested parties. During these trials, the law will not require that you be kept together during break for meals or at night. When you return to the courthouse from an adjournment for a meal or at night, please go directly to the jury area. That's where you are now, where we've designated you. This will lessen the opportunity for any accidental meeting with a person that you may not know is involved in the case. There will be coverage in this case by the newspaper, television, and other media. Probably you will see some things on social media, which is why I want you to stay off of social media. You should be very careful not to read that, watch that, look at that in any way, okay? Again, I remind you, you cannot investigate any facts or visit any scenes depicted in the evidence, and you cannot do any independent research in this case. All right, this concludes my preliminary instruction.